about the leg brace that's on him, but I saw no need to continue that.
Yes, sir.
All right, so, motions.
Judge, at this time, we would renew our judgment of acquittal, even in the light most favorable to the non-moving party in the state attorney's office and the case law provided on my original judgment of acquittal. Your Honor, I believe now, based on the evidence and testimony, the state has not met their burden of beyond a reasonable doubt that self-defense was not an issue, and the hypothesis that is reasonable that Mr. Dunn has presented of his innocence. And Judge, based on the previous motions and case laws I renew, I incorporate that to this, even though the burden now shifts to no trier of fact could rule against that based on the reasonable hypothesis of innocence and the lack of evidence the state has presented, the conflict in evidence the state has presented, and the evidence that they have presented. Your Honor, I must dismiss this case under judgment.
Ms. Corey.
Yes, Your Honor, in the light most favorable to the state, our case has gotten significantly better because all of the conflict that directly pertains to justify the use of deadly force now comes from this defendant. Most of the testimony centers around his testimony, and which is the case presented by the defense, has been refuted by the state, has been contradicted by state witnesses who appeared here under oath. He's now become a witness like any other witness in the case, which allows the jury to apply the rules of deliberation and the credibility, weighing the credibility of the witnesses to his testimony as well, which makes it a jury question as to whether or not they believe anything he said. They can believe anything he said, they can choose to disbelieve all of what he said. And the state will be able to argue to this jury that he made so many inconsistent statements and omitted so many statements that he now deems to be so critically important that his testimony simply is not worthy of belief. And his choosing to testify after you have fully colloquied him about that choice makes him subject to those rules for the jury to be able to weigh his testimony. So it's not for the court alone to decide whether his testimony gives him self-defense. That would have been for a prior hearing in front of this court. Thank you, sir.
You're very welcome. I will find that from the evidence presented, even with the evidence that's presented by the defense, that there is obviously a prima facie case for first-degree murder, 3 counts of attempted first-degree murder, and shooting into an occupied dwelling, that the issues are such that they can and should be considered by a jury because they can weigh the credibility of the defense as far as it relates to justifiable use of force or excusable use of force. So for those reasons, the motion for judgment of acquittal is denied. Ms. Corey, Mr. Guy, what's your pleasure from here?
Judge, we have one witness we can call that should take maybe 10 or 15 minutes, and then we'll have a video. So we'll have to get that queued up, Blake. And there's one issue on the transcript, which is in the electronic file that we need to address with the court. We held it in abeyance.
All right, well, let's address the transcript issue now so that we can, and at the same time, you can be getting somebody ready to go on this video that you're talking about.
Yes, sir.
The witness that you're talking about calling, is it a police officer or a civilian witness?
Civilian.
Okay. Is this listed as something in particular?
You mean at the bottom of the transcript?
Well, I'm wondering, is it under depositions, the transcript?
No, sir, it should just be transcript of the defendant's interview.
I see it.
Could be under-
I see it.
Yes, sir. Judge, I'm just doing.
I'm looking at something, well, there's 2. I assume they're probably the same, but I don't know that for a fact.
Do they both say Mr. Stroll's copy?
Yes.
Okay, well, whichever one the later one is, Judge.
Okay.
Basically, we rejected many things that are in light gray at Mr. Stroll's request, and of course with our agreement that pertain to matters not pertinent to this jury. And then, of course, we redacted once Mr. Dunn even made an equivocal request for counsel. However,
Okay.
there's one comment. It should be the last one in red by Mr. Dunn. And
Page, please.
It's the last page, Judge, so page 37 of 37 is what's shown on mine.
Uh, 37 in red.
Yes, sir. You might want to refer to the end of page 36 where the state starts to redact just about everything. And then there are 3 more statements that don't pertain to much of anything, except it does explain what the conversation is. And then the state submits that Mr. Dunn makes a completely spontaneous statement, not in response to the conversation that he's having with Detective Musser about a phone or phone numbers. And this is the quote, me too. I mean, if there is, it's probably about 5 things I could have gotten done differently last night, but unfortunate, it turned out the way it did. And we submit that that's spontaneous and does not violate his invocation of right to counsel.
Well, first off, let me ask Mr. Stroll, are you okay with everything they've redacted, not counting that?
No, Judge, and it starts on page 34. This is all intrinsically intertwined from 34 to 37. It does come a point in time where Mr. Dunn says, do I need a lawyer? Matter of fact, Detective Oliver stops and then clarifies, are you asking me for a lawyer?
Please tell me where you're reading from.
Judge, if you go to page 34, you'll see gray where they do take out Oliver, Dunn, and Musser.
Right, let me just read.
Oh, it's my 34, Judge.
No, I think it's the same, I'm in the same place. I just want to read the part right before it.
Well, I was going to go on to page 35, Judge.
Well, I'd like to get the context if you don't mind.
No, that's okay. I was pointing out if you go to 33, Judge, the state's already agreed to redact out.
You told me to go to 35, now you want me to
Oh,
go
no,
back
I'm
to
sorry.
33.
When you said you wanted the context, Your Honor, I apologize.
I think I can get it from 34.
Okay. On page 33, the state took out, do I need a lawyer, Judge? So I apologize. That was the context. 34, there's more taking out about a lawyer. But then if you go to 35 at the very top, they start saying, remember the rights we went over, just the mere fact that you mentioned the word in this room, that all needs to come out, Judge. And even Mr. Dunn says, not right this second, but will in about 2 seconds.
Right.
And then if you go down there, then the police kind of start going through a little bit more, and then sorry.
I agree.
Oh, no, I'm just saying that.
Relax.
Sorry, Judge. I'm just going to show you on page 36. It continues, Judge. That's all.
I really want to get this moved along, so I agree with you, Mr. Strolla. I think Ms. Corey or whoever's doing this on page 35, when Musser asks, remember the rights we went over and said, if you decide, that needs to come out, as does where Mr. Dunn says, not right this second, and maybe and then says, but will in 2, whether that means 2 or a couple.
Judge, Detective Oliver needs to come out under Musser as well. He said, but just for the mere fact that you mentioned the word in this room. So Musser and Oliver need to come out, Your Honor, at the top of 30.
I know that.
Oh, I didn't hear you say the second paragraph, Judge. I apologize.
I'm talking about the whole thing.
Okay, yes, sir, Your Honor.
I think it comes out all the way down to where Oliver says, okay, question mark. And then Mr. Dunn says, I understand, I appreciate it. What I was gonna say, it's too cheap to call them epithets. They were threats. You're dead and you're dead bitch. So I think it comes out and we start again with Oliver at okay. Is that acceptable, Mr. Strolla?
Judge, also at the bottom.
I know we're gonna keep going further.
Oh, I'm sorry, yes, as at that point, yes, sir.
So
I
above
apologize.
that, we take out.
Yes, sir, Your Honor, yes, sir.
Mr. Dunn, is that acceptable to you? All right. So we start with Oliver, okay. Mr. Dunn's answer is in. Oliver says okay again. Dunn's answer is in. Musser, this is all okay. That gets us to page 36. Everything's going along fine. We get to where the state has it grayed out. And so that Mr. Dunn's response there is fine. The grayed out part obviously comes out. You don't have grayed out the part where it says, I don't know any phone numbers, it's all in my phone. And that seems to me to needs to come out. There's no context to it.
Well, I only put it in there so you could see those two statements leading up to what we're suggesting is a spontaneous statement, Judge. I'm happy to take those out if the court wishes. I only wanted to give you context. Judge,
I see that, but I don't know how you can make it connect.
well, and that's the difficulty. And Judge, may I go ahead and say one thing?
Yes, ma'am.
We believe that the detectives did exactly what they're required to do under the case law, that they had an equivocal request. Judge, can you give us 3 minutes? And what we may do is look at the part you said take out a part, then
Right.
there's more in. Give us a second to analyze that. We may just cut it off
Okay.
at that last point.
All right.
Just give us a couple minutes, Judge. All right, Judge, if it makes everything easier, you tell me the point on, I think you started on page 33. You tell me where to take it out and I'll do it. Provided Mr. Strolla completely agrees with all of that coming out,
Well,
because
I
don't
think we
want-
already did, but I'll do it
No,
again.
no, Judge, we're saying we'll take everything else out. Just tell me the point where you started, because we jumped around a couple pages.
Judge, if I may be of help, Your Honor.
But Judge, what I would like you to call.
On page 33, there's the gray part.
Uh-huh. You want it out from there now?
I think that's what Mr. Strolla wanted.
You are correct, Your Honor.
So you're good up to Musser. Okay, is there, go ahead. That's when Mr. Dunn talks about, do I need a lawyer? So that grayed area comes out.
Then what we're gonna do, Judge, is go ahead and take everything out, but what I'd like the court to do, if you would, is colloquy Mr. Stroll and his client that they're not gonna argue that they didn't have the doctrine of completeness.
So you're gonna end it there, and we're not gonna worry about the red part.
That's what I'm offering to do in an abundance of caution
Okay.
to protect the record, but I would like you to colloquy them so there's no
Sure.
issue on appeal.
Mr. Stroller, you understand what she's saying.
Yes, sir.
Do you have any objection to it stopping there?
Based on my own motion, Your Honor, as an officer of this court, I can't have an objection because it was my objection to have it come out.
I understand that, I just want you on the record.
I am on the record multiple times.
All right, Mr. Dunn, what's happening here is this is your interview transcript. And I assume you've got a copy there before you. There is a point where, and you've probably looked at this, there's grayed out areas that were objectionable, that the state was recognizing could have some problems, but they still wanted some other areas in. Now what they're saying is that you'll get to page 33, kind of towards the, it's in the middle of the page, where Musser says that's pushing 20 years, and you say, yeah, I had it before my daughter was born, she's 22, so yeah.
And Judge, we would.
And I'd say that you end it right there.
Yes, sir. Yes, sir. I was just gonna
So
say.
they're agreeable to ending it there, and nothing, that's where this thing's gonna end. So there are some other areas that are in black. I don't know if they were objectionable to you or Mr. Strolla or not. Some of them may have been, some of them may not have been, but they're all gonna be coming out. So the thing will end there. What the question is when you start talking about a doctrine of completion, is to have the complete document, or whatever the case may be, we'll just call it a document, in evidence. Obviously, this would not be the complete transcript. So the state wants you to acknowledge that you're not objecting that this is not the complete transcript, because in essence, you want some of it out. And so that's kind of where we are. You understand what I'm saying?
I believe I follow.
Okay. You need a minute with him, Mr. Strolla?
If I can, Your Honor, just because we are putting the colloquy on the record, I'd like to make it clear that Mr. Dunn has gone through each paragraph and wants, and
Okay.
agrees with counsel, Judge.
Well, then, take the time.
Thank you, Your Honor.
While you're doing that, if I can, how long is this when it's cut down?
Now that it's cut down, Judge, it's probably 45 to 50 minutes. And also, we don't intend, because it is fairly clear, and now they all have their own monitors, and we don't intend to offer a transcript, so we won't be asking you to read that during instruction.
Okay.
So I would estimate 45 minutes, but I'll know for sure as soon as you tell me what to cut.
Do I, and I hate to interrupt you, but is anybody going to ask me to read the video recording, audio recording instruction? I mean, there's nothing spliced out of the middle of this thing, it's just, oh, there is?
Yes, Your Honor. There are
Okay.
some comments that were already pre-agreed upon.
All right, so I need to read the video, audio instruction.
Yes, that one, you just don't need to read a transcript instruction.
Right, okay. All right. All right, Mr. Stroller, you've had a chance to talk to Mr. Dunn.
I have, Your Honor, and I've explained what intrinsically intertwined was and what I moved and why I moved for it. Mr. Dunn does agree with me, and if you want to ask him that, or if you can just take me as my word.
No, I'm gonna ask him. So
Yes, sir,
you're
Judge.
good to go with this audio, video ending at page 33, with Mr. Dunn's answer. So, yeah, I had it before, my daughter was born, she's 22, so yeah, that would be the end. Mr. Stroller.
Yes, Your Honor.
Mr. Dunn, do you understand that would be the end of the video and audio of your interview with the police?
Yes, sir.
And you have no objection to the rest of it being deleted or left out?
None.
Okay. All right.
And Judge, how about the ones that were previously agreed to, but I don't think have been mentioned on the record?
The,
The other grayed out areas in the earlier pages
Oh.
of the transcript.
right.
Several comments about what good boys the victims were. We believe that may come close to a Florida Supreme Court case that came out last year, so we took those out on our own. We also took out what Mr. Strolla asked us to about the defendant's prior DUI. So I want to make sure he also agrees with those statements
Okay.
coming out.
I mean, those were things that, Mr. Stroller, you had requested be deleted previously anyway.
Yes, Your Honor.
And so there are other things, Mr. Dunn, that are grayed out, that they've been grayed out for quite some time. And you understand that those aren't coming in there, which is one of the reasons I read this instruction, because this video is gonna look like it's been edited to some degree. But you're in agreement with those other areas which we'd already really talked about, or your attorney had, not coming in as part of the video.
I am here.
Okay. All right, so we're good to go on the video, so we can call the witness, and then after the witness, we go to the video. Is that the way you're planning on doing that?
Yes, sir. But we'll have to put a witness on for the video.
Right.
Detective Musser, and they're redacting the video as we speak. They'll have to just drive it over here from our office, which is still a mile away.
Yes, yes.
But they're working on it right now, Judge. The way we've agreed to it makes it much easier, so we should have that.
Well, other than those two witnesses, are there additional witnesses that you anticipate in rebuttal?
Judge, oh, I apologize. There's just one other line, if I can see the state.
Just a minute.
Judge, we may have one more witness to queue up and just play a couple of his jail calls to rebut something he said on the stand.
Okay.
Judge, if they do that, I'd like to know what it is. We've had some pretrial discussions about that. I want to make sure those
Okay,
are clear.
Part where we talk about buzzing.
I would like to know the date, time, and call, Judge.
Ms. Corey, he needs
Before
to
they
know the
do.
date, time, and call,
Yes, sir.
so that if we need to discuss it, because I don't know anything about what might be used in that regard.
We will get him the dates of the calls and try to get him to place where he queues up to the, that's specifically what it goes to. Is
All right.
he himself uses the phrase buzz music, which he denied on the stand today, and I think there's 2 phone calls.
Okay, well, we just need to get those particular two and get them queued up. Now, you had something else, Mr. Stroh?
Judge, I just think there's one line in here right before the state starts redacting. I think there's one more that I need to speak with the state to see if they'll agree. If not, I can address it with the court.
Go right ahead.
So we need page 1.
Page 21, it's the last line right before we gray out Musser's last part of that paragraph. Page, my 21 of 37.
You talking about where Musser's talking?
Yes, Your Honor, yes, Your Honor, the very last line in black, right before the agreement.
What's he gonna, I'm gonna kill you and get out of the car, and we're talking about a kid.
And I'm not agreeing to gray that out, Judge. There's nothing objectionable about that point. I think the following sentence is, and I'd like to get that on the record, you know how many times this kid's been to jail? Never. He has no history of violence in this. It's not like we're getting some street bug. I think that statement and that one alone could come close to violating the opinion in the Jackson
Well, that's why it's out.
Well, that's.
So,
he took that out.
I understand, Mr. Strolla, what, is it that last sentence you're talking about?
Yes, Your Honor, I believe that's also.
Where it starts what's,
Yes, Your Honor.
and the reason you want it out is what?
It's very similar to prior improper good character, and it also is bolstering the state's case about he's a child, Mr. Dunn's a man, it's not self-defense. Part of the instruction they're gonna get is you may consider the size. I think that's improper, and it still goes on that same line of the last two sentences, Judge. It's improper bolstering.
It doesn't even come close to the last two. The last two talk about I assume we're talking about Jordan Davis, that he's never been to jail,
Right.
and he has no history of violence.
And again,
And this is the officer talking, the detective, and it's
Right.
not like we're getting some street thug,
right.
which the state has agreed to take out.
Correct, Your Honor.
The part prior to that, I don't see anything wrong with it, so your objection's overruled.
And Judge, for purposes of documenting the record, would you like for me to put three things in there? A copy of the full video, a copy of the redacted video, and the transcripts that go with each that show what we voluntarily took out and what we agreed to today, so that there's a full record?
Probably, that would be
Put
best.
it in as court.
Well, the redacted video is gonna be in evidence.
Sure.
The full video I would have as I guess we could call it a court exhibit. The
Yes.
transcript of the full video would also be a court exhibit. And probably we just call the transcript of the redacted video another court exhibit because the jury's not gonna get it.
I'll put that, what I'll do is indent under that on our exhibit list and put it in there, but it will never be seen by the
Right.
jury, it'll just come in as an exhibit.
Is that all right with you, Mr. Stroller, to do it that way?
Yes, Your Honor. And those, again.
Not that you would necessarily know about all that, Mr. Dunn, but is that all right with you that we do it that way? I mean, these things need to be in the record so that if there's an appeal, they'll be part of the record and some appellate court could look at what the full video was and they'll have a better sense of what was taken out. And they'd have a transcript of both, so they could compare the two. You understand?
Yes, sir.
All right.
And if I could just let my client know, that does not go back to the jury, just the evidence of the redacted video.
The only thing that would go back to the jury is the disc that shows the actual video and audio. They won't even get a transcript of what I'm calling a redacted version of your interview. They just get to see the video and the audio part of it. You understand that?
Yes, sir.
Okay. All right. Can we resume? Or, well, I'm just curious as to, when we put this witness on, are we gonna then take another break while we're waiting for this redacted version to make its way from your office that's over a mile away?
Judge, they're very close to having it done. I can only promise you that it's a top priority and they know that. And they'll get it here as quickly as they possibly can.
Judge.
Well, why don't we, I don't wanna keep them waiting, but when I bring them back in, I don't wanna really be up and down, up and down. Well, because I'd rather do this witness and get right into that video, because it's 45 minutes worth of video. I wish what we could do while we're sitting here waiting to know that the video's gotten back to this building is queue up these calls for Mr. Strolla, so if we need to talk about those, we need to talk about them now.
Okay, yes, sir.
So let's do that.
Judge, there's a.
Sure. Yes, ma'am. All right. So, we're back to calling a witness and then playing the video, and there's a move afoot to reach a stipulation as to two of these phone calls and what may have been said. And so whoever's going to work on that can work on that while we're doing this other bit of business. So is the state ready to proceed?
We are, Your Honor.
Mr. Strolla?
So ready, Your Honor.
So I'll bring the jurors out and tell them that the state intends to call or put on some rebuttal evidence. Is that what you want me to say, Ms. Corey?
I'm sorry, Judge, I was asking about the video.
I'll bring the jury out and tell them that the state is going to put on some rebuttal evidence.
Yes, Your Honor.
That acceptable to you, Mr. Strolla?
Yes,
Okay. Bring the jury on in.
Jurors entering the courtroom.
All right, welcome back, ladies and gentlemen. You can have a seat. As I mentioned to you, I guess it was yesterday, the state had rested their case, and then I mentioned a moment ago the defendant had rested their case. The state now has an opportunity to present some rebuttal testimony or evidence to you, and so in that regard, the state's next witness is?
Your Honor, the state calls Rhonda Rouer.
Rhonda Rouer, please. Ms. Rouer, if you'll come up to the front again for me, please. And you were sworn the other day, but I'll have you come in and raise your right hand. The clerk will administer the oath to you again.
Do you solemnly swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, ma'am, if you'll come right around here and resume the seat. And just remember to speak loudly into the microphone so everybody can hear you, all right?
Yes, sir.
All right, Ms. Wolfson.
Good afternoon, Ms. Rouer. I'd like to turn your attention to the morning of November 24th. Do you remember that drive home to Brevard with the defendant?
Yes, I do.
Now, while on that drive home, Ms. Rouer, did the defendant receive a phone call?
Yes, he did.
And who called him?
It was our neighbor.
Could you state his name?
Well, I can't pronounce his last name. Am I allowed to say his first?
Yes, ma'am.
Ken?
Okay, and do you know his last name to be Les Calais?
Yeah.
Now, Ms. Rouer, how did you know that that was who called the defendant?
It was on speakerphone.
Did you hear that conversation?
Yes, I did.
So you could hear both Mr. Les Calais as well as the defendant?
Yes, I could.
During that conversation, did the defendant tell Mr. Les Calais that you all were heading back home instead of going to St. Augustine?
Yes.
And did the defendant also tell Mr. Les Calais that that was because you were not feeling well?
Yes.
During that conversation, did the defendant ever mention that he had been involved in a shooting in Jacksonville?
No.
Did the defendant ever mention that he needed to speak with Mr. Les Calais when he got back home?
No.
Did the defendant ever mention to Mr. Les Calais that he had something important that he needed to talk to Mr. Les Calais about?
No.
Were plans actually discussed for that night instead?
They indicated. Did you want me to just say yes?
Just whatever you remember.
They said that if I was feeling better, that I should join them. That we should join them for evening out.
Okay. But there was no discussion of the defendant going over to Mr. Les Calais' house when you all got back home?
No.
Now, Ms. Rouer, I'd like to then go back to November 23rd of 2012, and that's right after the shooting.
Okay.
When you and the defendant got to the hotel back to your Sheridan, did you
Yes.
ever see this defendant reach to take his gun back out of the glove box?
No.
Did you ever tell the defendant not to take the gun out of the glove box?
No.
And then Ms. Rouer, also on November 23rd, 2012, after the shooting, when you came out of the gate gas station and you got into the defendant's car,
Yes.
did the defendant ever tell you he saw a gun in that red SUV?
No.
Did the defendant ever tell you that he saw a weapon of any kind in that SUV?
No.
There was no mention of a stick.
No.
There was no mention of a shotgun.
No.
There was no mention of a barrel.
No.
There was no mention of a lead pipe.
No.
Back in the hotel room, Ms. Rouer, that same night, did the defendant ever tell you that he saw the boys with a firearm?
No.
Did he ever tell you that he saw the boys with a weapon?
No.
On the 2-hour drive back to Brevard the following morning, did the defendant ever tell you that he saw a gun in the SUV?
No.
And on that 2-hour drive, did he ever tell you he saw a weapon of any kind in
No.
that SUV?
No.
You have a moment, Your Honor?
Yes, ma'am. Mr. Stroller.
Yes, Your Honor. Mrs. Rouer, we saw your mental state the other day when you testified. You were on the stand, you recall crying and breaking down.
Yes, I do.
You recall being escorted out by a bailiff to keep you up.
Yes, I do.
You also remember telling this jury that you actually were worse off, closer in time to the shooting than you were even that day mentally.
Yes, I did.
Isn't it true, there's no way you can remember everything Mr. Dunn said to you because of your mental state?
I suppose.
Okay. And isn't it true in your mental state that you had pre-existing conditions with anxiety and issues like that? Isn't that true?
Yes.
Okay. And after this incident, you actually sought counseling. Isn't that true?
Yes.
And because of this incident and what you went through, you're actually on prescription medication. Isn't that true?
Yes, I am.
No further questions, Judge.
May she be excused.
Yes, Your Honor.
Mr. Stroller.
Yes, Your Honor.
Thank you, ma'am. You're excused.
Thank you.
State's next witness.
Judge, the state next witness is Detective Musher. We do not yet have the report that we were seeking.
Okay. Well, want to take another break? Any estimate as to time that it might arrive? Something is coming from the state attorney's office. They have not moved to their new building, which will be adjacent to this building. They're still back over at the old building where the old courthouse was. So somebody's having to travel from there to here. And that's what the situation is. So do we have any earthly idea? 10 minutes?
They said it's on the way, so in an abundance of caution, can we have 10 to 12 and a half minutes?
12 and a half? How about 12 minutes and 22 seconds? Let's just go ahead and break until 3:30, shall we? Again, sorry about that, ladies and gentlemen. Don't discuss the case among yourselves with others. We'll be back in about